Good morning. This is the hearing of the appeal in the case of Bresco Electrical Services Limited and Michael J. Lonsdale Electrical Limited. This appeal is being heard remotely with each participant sitting in a different location in accordance with the government guidance issued in response to the COVID-19 crisis. I'll ask you to be patient with us if we encounter any difficulties while our IT team try to sort them out. Footage from today's hearing will be available on the court website within the next 48 hours. To reduce interference or echoes and to prevent the camera from being attracted away from the speaker, I've asked our IT team to keep muted the microphones of everybody other than the person who is speaking at any one time. If somebody else wishes to interrupt a speaker, then they will indicate that wish by raising their hand so that the speaker can see them and pause, and the IT staff can then unmute their microphone. Everyone will have to pause before speaking because there is a time lag between the person's image appearing on the video and the microphone being activated. I'll introduce each of my colleagues in a moment and ask them to say good morning so that we can check the sound as well. And then I will invite the counsel for the cross appellant, Michael J. Lonsdale Electrical Limited, to introduce counsel and to begin her submissions. But first, let me introduce my colleagues. First of all, Lord Briggs.
Good morning.
Lord Kitchen. We can't hear you.
Morning.
Thank you. Lord Hamblin.
Good morning.
And Lord Leggett.
Good morning.
I now will invite Ms. Fiona Sinclair, Queen's Counsel, to introduce counsel and begin her submission. Ms. Sinclair.
My Lords, I appear with Mr. Thomas Crangle for the respondent and cross-appellant. Learned friends, Mr. Peter Arden, UC, Mr. Ben Shaw and Ms. Chantal Stennings appear for the appellant and the respondent on the cross-appeal. The jurisdiction issue raised by the cross-appeal is logically prior to the utility injunction issue raised in the appeal, and that is why, in slightly unorthodox fashion, I address you first. It was also thought by Mr. Arden that it would not be useful to take the cross-appeal and the appeal discreetly and in sequence. So in a further step away from convention, I'm going to address you on the appeal to which I respond before you hear from Mr. Arden. We hope that will work, but of course we're in your hands if that approach doesn't commend itself to you. My Lords, the matters before you concern the interface between two statutory operations: insolvency set-off in corporate liquidation, and of course in distributing administration, but we're not concerned with that in this case, and Secondly, the implication into construction contracts of provisions for adjudication. I propose to structure my submissions in this way. First of all, I'll look at the material features of construction adjudication. Secondly, the material features of insolvency set-off in liquidation, in compulsory or creditors liquidation. Thirdly, the jurisdiction issue, the issue on the cross appeal itself, and why I will invite you to allow the cross appeal, restore the decision, the finding of Mr. Justice Fraser at first instance, the then judge in charge of the Technology and Construction Court, and finally the utility or injunction issue. And on that, I will invite you to dismiss the appeal and uphold the decision of the Court of Appeal. And my lords, first of all, the material features of adjudication. And I propose to spend just a little time on this because it's a proper understanding of what adjudication is, what it was intended to do, and what it is capable of doing. It is at the heart of the issues before you. The central question, the fundamental question on the cross appeal is this: do the words dispute arising under the contract, in section 108(1) of the Housing Grants Regeneration and Construction Act 1996, include the dispute as to the net balance which is generated by statutory insolvency set-off as between a company in liquidation and a creditor with a cross-claim. Now, the 1996 Act, and since the title is something of a mouthful, I'll refer to it, if I may, as the Construction Act. The Construction Act does not answer that question expressly. And so in the usual way, it's appropriate to consider the mischief at which the statute was aimed, because a purposive construction is appropriate. Then the words in question in the context of the statute as a whole, and that is why I propose to spend a little time on the material features of adjudication as expressed in the statute and as explained in case law. And then, of course, the words in question themselves. Starting with the purpose of the Construction Act and the adjudication regime, first of all. It's been said many times that cash flow is the lifeblood of the construction industry, to which the natural response is, well, cash flow is the lifeblood of most forms of commerce. But my lords, there are two features which distinguish construction projects. First of all, they endure, sometimes for years. And secondly, they rely particularly heavily on the process of subcontracting. The success of construction projects depends upon the success of a large number of subcontractors, typically of decreasing size, and forming the various supply chains which enable the main contractor to perform its obligations to the client or the employer. And those two factors have two consequences. First of all, interim or progress payments to contractors or subcontractors have long been a feature of construction projects. Typically, payment is made on the basis of a periodic assessment and certification of the value of work done to date, but it is not a final assessment. There is scope for later revaluation at the end of the contract, normally, when the parties settle what's referred to as their final account. And the second consequence of these features is that disputes between parties in the contractual chains, which can be lengthy and elaborate, have the potential to stifle cash flow, but also to cause delay and additional expense, both before and after projects. And my lords, by the 1970s, there was an abiding concern that rights of set-off were being misused as a pretext to delay payment or to withhold it altogether. Lord Justice May, in one of the early decisions on the Act in the Court of Appeal, summarised the history far better than I could. If you could go, please, to the case of Pegram, excuse me, Pegram Shopfitters and Tally Vale. I understand that you have electronic bundles. So if I just give you the page number of this beginning of the report, which is 2252, and then on the, excuse me, the next page, Lord Justice May's judgment starts at the foot of page 2253. And I would ask you to read the first 3 paragraphs of his judgment, which summarise the history and the background to the Construction Act. My lords, if you would turn on to page 2255, in paragraph 9 of his judgment, Lord Justice May used the epithet "pay now, argue later," which is a recurring description of the policy behind the Construction Act, both its payment provisions and the adjudication regime which backs them up. My lords, you will have seen from paragraph 2 of Lord Justice May's judgment and our written case that at one stage in the history, before the Construction Act was introduced, parties took to providing for adjudication by their contracts. Before I move on from the history, I invite you to note that even at that stage, the court rebuffed the suggestion that adjudication was a form of arbitration. At page 1510 in the authorities bundle, you have the decision of the Court of Appeal in 1990 in A. Cameron Limited and Molam. That was a contract made on Joint Contracts Tribunal standard subcontract form, the DOM1 form. The subcontractor secured an adjudicator's award in its favour. It sought to enforce the decision under Section 26 of the 1950 Arbitration Act on the basis that the decision was an award on an arbitration agreement, and the application failed. Page 1521, at the foot of the page, in the recitation of the contractual provisions which allowed adjudication in that case, you see the final paragraph: the adjudicator's decision shall be binding on the contractor and the subcontractor until the matters upon which he has given his decision have been settled by agreement or determined by an arbitrator or the court. And of course, as we'll see in due course, that approach, a provisional decision, is echoed in the Construction Act. So a similar landscape, albeit under contract. But page 1524, Lord Justice Mann, in the penultimate paragraph, having noted the finding of the learned judge in that case that the adjudicator does not perform an arbitral function, he doesn't make a final award definitive of the parties' rights, Lord Justice Mann referred to the argument that there were similarities between adjudication and arbitration. But in the final, towards the end of the paragraph, he said, an adjudicator's decision is binding until determination by an arbitrator. The decision has an ephemeral and subordinate character, which in our view makes it impossible for the decision to be described as an award on an arbitration agreement. So at a very early stage, the court was astute to distinguish adjudication and arbitration, and that's a matter to which I shall have to return later in my submissions. May I then take you to the Construction Act itself? It's a short act. In fact, many of the problems stem from the fact that it's a short act. It was amended in 2009 with effect from October 2011. But I invite you to look at it in its current form at page 485 in the authorities bundle. Part 1 need not concern us. Part 2 begins at page 486. And Part 2 is divided into 4 parts: introductory provisions, adjudication, payment, and supplementary provisions. The introductory provisions, it's section 104, define construction contract by reference to construction operations. And section 105 on the next page explain the meaning of construction operations, that there are significant exclusions. For example, certain activities such as mining, power generation, and others are not included. Contracts of supply alone are not included, and wholly contracts with a residential occupier are not included. That's section 106 on page 489. At page 491 is section 108, which is the provision of most importance to this appeal. A party to a construction contract has the right to refer a dispute arising under the contract for adjudication under a procedure complying with this section. For this purpose, dispute includes any difference. The contract shall include provision in writing so as to A, enable a party to give notice at any time of his intention to refer a dispute to adjudication, B, provide a timetable with the object of securing the appointment of the adjudicator and referral of the dispute to him within 7 days of such notice, C, require the adjudicator to reach a decision within 28 days of referral, or such longer period as is agreed by the parties after the dispute has been referred. D, allow the adjudicator to extend the period of 28 days by up to 14 days with the consent of the party by whom the dispute was referred. E, impose a duty on the adjudicator to act impartially, and F, enable the adjudicator to take the initiative in ascertaining the facts and the law. And then section 108(3, echoing what we saw in the contract in Cameron and Molam, the contract shall provide in writing that the decision of the adjudicator is binding until the dispute is finally determined by legal proceedings, by arbitration if the contract provides for arbitration or the parties otherwise agree to arbitration, or by agreement. Parties may agree to accept the decision of the adjudicator as finally determining the dispute. And this section operates through the implication of the scheme for construction contracts. You see that at section 108(5, if the contract does not comply with the requirements of subsections 1 to 4 above, the adjudication provisions of the scheme for construction contracts apply. I'll come on to that in a moment, my lords. The only other provision in this part of the Act is section 108A, which was added by amendment, and it deals with costs. And it provides, in short, that a contractual provision which concerns the allocation as between the parties of adjudication costs is ineffective, except in two cases. First, it's made in writing in the contract, and it concerns the adjudicator's fees and expenses. The parties can confer on him a power to allocate those. Or B, it's made in writing after the giving of notice of intention to refer the dispute to adjudication. So, in other words, after the adjudication has begun with the notice of intention, the parties may then agree to confer on the adjudicator power to allocate, to award the costs of the adjudication, but not otherwise. My Lords, section 109 up until 113 concern payment. By a mixture of direct obligation and provision that contracts must contain certain mechanisms, the Act provides for a fairly regulated system of provisional interim payments during construction contracts. The parties are required to provide for exchanges of notices, payment application, payment notice, and finally a pay less notice if the paying party is going to pay less than has already been notified. And perhaps I need only take you to section 111, excuse me, page 497. Subject as follows: where a payment is provided for by a construction contract, the payer must pay the notified sum to the extent not already paid on or before the final date for payment. My Lords, in a decision of the Court of Appeal last year in a case called S&T and Grove Developments, to which I'll take you in due course, the Court of Appeal decided that that provision imposes a direct obligation to make immediate payment in the circumstances in which it applies. And it does so plainly to protect cash flow and defer argument until later. My Lords, section 114 on page 501 at subsection 4 provides that where any provisions of the scheme for construction contracts apply by virtue of this part in default of contractual provision agreed by the parties, they have effect as implied terms of the contract concerned. The scheme is made by regulations and you have it at page 517 in the authorities bundle. And very often parties simply expressly incorporate the scheme in its entirety. Some of the major forms, standard forms of construction contract do that. It's common also in smaller contracts. It's what the parties did in this case. They expressly incorporated the scheme with only an amendment to paragraph 25 of the scheme, which I'll come to in a moment. And the structure of the scheme is this. Paragraph 2 on page 518. Where a construction contract does not comply with the requirements of section 108(1) to 4 of the Act, the adjudication provisions in part 1 of the schedule to these regulations apply, and a similar provision is made at paragraph 3 in relation to the payment provisions of the Act, which will be replaced if they're not compliant with the Act with the provisions of part 2 of the scheme. The scheme is in the schedule, which starts at page 519, and it starts with part 1 adjudication. Paragraph 1 reflects almost exactly the wording of section 108, subsection 2A of the Act. Any party to a construction contract, the referring party, may give written notice, the notice of adjudication, at any time of his intention to refer any dispute arising under the contract to adjudication. At any time was added by way of a clarificatory amendment so that the reflection of section 108, subsection 2 was exact. Page 524, paragraph 8 of the scheme provides that the adjudicator may, with the consent of all the parties to the disputes, adjudicate at the same time on more than one dispute under the same contract. And subparagraph 2 makes similar provision for adjudication of disputes under more than one contract, if those disputes are related. But under the scheme, if the adjudicator is to have extended power in either of those ways, the consent of both parties is required. My lords, paragraph 19 at page 529 reflects the highly abbreviated timetable for adjudication, which you saw in section 108. And paragraph 21 on page 530 confirms the obligation of a party to comply with the decision of an adjudicator on the publication of that decision. Paragraph 23, subparagraph 2 on page 500. I'm so sorry, my lord.
Not at all. I'm just going to raise with you what's meant by a dispute. Paragraph 1 of the scheme on page 520 is where the expression, I think, first appears, enabling any party to the contract to give notice of his intention to refer any dispute arising under the contract to adjudication. Now, could, for example, a disagreement as to the amount due on the final account be a dispute arising under the contract?
My lord, yes. Yes, it could. I'll go on. Sorry.
If I can just pursue that a little further, the amount due might, on a final account, might might require a view to be taken on a number of issues. For example, if there had been an overrun on the contract, whether that was due to causes which entitled the contractor to additional payment, or on the other hand, might result in hers incurring some form of penalty under the contract.
My lord, yes. A dispute can encompass numerous issues.
Yes. And would it be right to say that those might be issues raised by either party to the contract?
There is a limitation on the authorities to the as to the issues which the responding party can raise. He is entitled to raise any defence to the complaint described in the notice of adjudication. So if he has a defence which operates as a set-off, that That's taken as encompassed within the scope of the notice of adjudication. But he could not otherwise raise what in litigation or arbitration might well be a counterclaim.
Right, that's very helpful. So a dispute referred by one party can encompass a set-off claimed by the other party, but not a counterclaim.
Not a counterclaim in the sense, the broader sense that we're accustomed to see in litigation or arbitration.
Yeah, and that's on the authorities on the interpretation of this.
My lord, yes, which I will come to. I'm happy to take you to those now.
No.
I was going to take you to them anyway, due course.
I'll be patient. Thank you very much.
Can you hear me? I have a question.
Yes, my lord.
I think you accept both in your written case and indeed, as you've just said, that you can raise a set-off by way of defence so as to bring in the disagreement in relation to your alleged set-off. Does that include equitable set-off as well as legal set-off?
My lord, I'm not sure that's a question that has been addressed in the authorities. The two guiding principles are that the scope of the adjudicator's jurisdiction is determined by the notice of adjudication. So depending on how the referring party describes the dispute, whether narrowly or widely, the scope of the referring party to bring in issues will vary. But the second consideration is the principle, as I mentioned, that the responding party is entitled to raise any matter in defence to the claim. So certainly legal set-off would operate, but possibly not equitable set-off. There is not the question hasn't been addressed head-on in case law so far.
Thank you.
My lords, just to finish off with the scheme, at page 532, there is the provision which directly reflects section 108 subsection 3, which we refer to as the quality of temporary finality, which an adjudication decision has. And then paragraph 25, the scheme makes provision, as I said, for the adjudicator to determine, first of all, he's entitled to his fees and expenses. And secondly, in the absence of a contractual provision under section 108A2, which determines the allocation of those expenses, he may do so. And my lords, just for completeness, in this case, the parties did make an amendment to paragraph 25, which doesn't offend the Act, but it's important that you see how it was put. That is at page 393 in the core bundle. The parties' contract provided at clause 48, the adjudicator shall be entitled to the payment of such reasonable amount as he may determine by way of fees and expenses reasonably incurred by him. The adjudicator's fees and expenses, and I'll omit the words in parentheses for brevity, shall be paid in equal parts by the company and the supplier. In the event that a party fails to pay his part, the company and the supplier shall be jointly and severally liable for the outstanding amount. The company and the supplier shall each bear their own costs of participating in the adjudication. As I will submit that this is a case where the costs aspects of adjudication are important, and that provision correctly reflected the generally accepted position, which is that an adjudicator is not entitled to award costs beyond his fees and expenses. So far as the purpose of the Construction Act and the adjudication regime in particular is concerned, it was introduced as a method of provisional interim dispute resolution, the principal purpose of which was to avoid disputes, especially payment disputes, which cause delay and disruption to construction projects. Now, I entirely accept that that is not exhaustive as a description of its utility, because a dispute can be referred after the end of a project. But it's clear from the history that that is the principal purpose of the Act. That is a situation to which it is principally directed the smooth and uninterrupted running of a construction project, normally involving numerous parties. As I said, as you saw, the Act is short. It has been explained and certain lacunae have been filled by case law. I'll come to some of that in a moment. But for the present purposes, there are four key features of adjudication. In ascending order of importance on this cross appeal and appeal, first of all, it is a cost-neutral procedure, as Lord Justice Coulson observed in the Court of Appeal. Secondly, there are limitations on the scope of what can be addressed in adjudication. Thirdly, the timetable, highly abbreviated as it is, gives rise to an inherent risk of error. There is a reliability question with adjudication. And finally, its unique quality of temporary finality, the quality which justifies the generous approach to enforcement of adjudication decisions which the court takes. And that is why, as you see in our written case, we submit it is quite wrong to suppose that adjudication is a form of arbitration light, if we can put it in that colloquial way. Lord, I just want to say one or two things about each of those features. First of all, cost neutrality. In the Court of Appeals, in Lord Justice Coulson's decision in the Court of Appeal at paragraph 56, he said adjudication is a quick process which can require a responding party to spend a good deal of money in a short space of time to defend itself from claims which may prove utterly hopeless, with no prospect of recovering those costs because it is cost neutral. My lords, you have seen section 108A does not permit the parties to provide in advance that one or other shall bear the costs of the adjudication, or indeed to provide in advance that an adjudicator will have power to award costs. And I don't need to take you to it, but it's in the authorities bundle at page 1754. The current judge in charge of the Technology and Construction Court decided in a case called Enviroflow Management in Redhill that the parties, that was the effect of section 108. My lords, the relevant paragraph of the judgment is paragraph 52, page 1770. I don't ask you to turn it up because we see from Bresco's written case that that is not in dispute. So cost neutrality is the first key feature. The second key feature is the limits on what can be referred to adjudication. My Lord Reed's question highlighted this, and there are a number of aspects to it. First of all, only disputes arising under the contract can be referred. Of course, whether that extends to the dispute as to the net balance which arises under statutory set-off under the insolvency legislation is a central question. And I'll return to that. But for present purposes, first of all, it's indisputable that arising under the contract does not encompass disputes between the parties which arise under a different contract, or which arise from dealings between them which have nothing to do with any contract, or not contractual in nature. Otherwise, it has been held that the broad permissive approach to the construction of arbitration agreements, which the House of Lords described in the Fiona Trust and Privilov case, should not be applied to adjudication. That's recently been doubted obiter. But my lords, could I take you to the Fiona Trust case to remind you of what I accept a very well-known dicta of Lord Hoffman. It's at page 1834 in the authorities bundle. And the decision there, of course, was that the words "any dispute arising under this charter" were wide enough to encompass disputes as to the validity of the contract. At page 1836 appear in paragraphs 5 to 7 the well-known reasoning of Lord Hoffman. At paragraph 5, perhaps if I just give you a moment to remind yourselves what Lord Hoffman said. My lords, the emphasis there, of course, was on the fact that arbitration is the party's choice. By contrast, statutory adjudication is never the party's choice. It is imposed by the Construction Act on qualifying contracts. In arbitration, principle of competence applies, and the arbitrator has power to decide his own jurisdiction. That is not the case in adjudication under the Act and the scheme. Indeed, one of the two reasons why the court will not, two principal reasons why the court will not enforce an adjudicator's decision is that the adjudicator arguably did not have jurisdiction. So his own decision is not binding. And thirdly, my lord, adjudication, unlike arbitration, is not an alternative to litigation. It is an additional process, an intermediate process, because it's binding only pending a final determination in litigation, arbitration, or by agreement of the parties. So well, those are reasons in my submission why the considerations which weighed with the court in the Fiona Trust case and dictated a broad permissive approach to the construction of the words under the contract do not apply in adjudication. There was also page 1838, paragraph 14, Lord Hoffman noted that the broad approach was also adopted in Germany, And Lord Hope in that case made the same point at the end of paragraph 31 on page 1842. Clearly, there was a concern to ensure that England, as an arbitral seat, was not at a disadvantage when compared with other centres of arbitration. That's a consideration which can never arise in relation to adjudication because it's purely a domestic process. I will take the position at first instance is that there is a decision called Hillcrest, Holmes and Beresford, which you have at page 837 in the authorities bundle, where the Technology and Construction Court, bear with me a second, held that a claim in misrepresentation, which arose, of course, under the 1967 Act, did not arise under the contract for the purposes of the Construction Act and the scheme. It arose under the 1967 Misrepresentation Act. In that case, it was pressed upon the judge, His Honour Judge Raynaud, sitting as a judge at the High Court, that he ought to adopt a broad approach to construction along the lines adumbrated in the Fiona Trust. He rejected that submission. That's paragraph 50 on page 853. Where he observed there was considerable force in the submission that Fiona Trust reasoning is inapplicable to adjudication clauses, which are there by reason of statutory intervention and not the free bargain of the parties. My lords, as I have just indicated, there are numerous other reasons to reject the submission that the Fiona Trust reasoning should apply. My lord, it's right that I mentioned to you another decision at first instance in the Technology and Construction Court, which touches on this. It's at page 869. It's a decision of, decision of Sir Robert Aikenhead sitting as a High Court judge in a case called J. Murphy and Sons and W. Mayer and Sons. My lords, you see on page 869 in the headnote, per curiam, there's no logical reason for thinking that there should be any difference in meaning or application between dispute resolution clauses or even dispute resolution arrangements adumbrated in a statutory instrument such as the scheme, whether in arbitration or adjudication, which call for disputes arising under the contractual or statutorily imposed dispute resolution regime to be treated jurisdictionally differently from those arising out of or in connection with the underlying regime. And in effect, the court there was observing that it could see no logical reason why Fiona Trust approach shouldn't apply to adjudication. Well, the first point to observe about that is that those observations of Sir Robert Aikenhead were obiter. The clause in that case, the operative clause, was a clause referring to disputes which arose under or in connection with the contract. So the wording already had the ambit ascribed by a Fiona Trust type construction. The dispute in this case arose because the parties made a further agreement to settle their differences at final account stage. The settlement agreement did not itself contain adjudication clauses, and so when a dispute arose as to its validity, the question was, does it come under adjudication provisions of the original construction contract. It did. It was a dispute arising under or in connection with, because the settlement agreement was in the nature of a variation to the construction contract. So in the event, the judge didn't have to decide whether section 108, paragraph 1 of the scheme ought to be construed in a way wider than the judge in the Hillcrest Homes case would accept. Moreover, Hillcrest Homes wasn't cited to the court in J. Murphy and Sons and Mayer. So the position at first instance in my submission is settled by Hillcrest Homes, and the obiter observations made in the Murphy and Mayer case do not disturb that. In any event, Murphy and Mayer was not concerned with a dispute arising not under or in connection with a contract, but arising under statute or by reason of a statutory entitlement, as in Hillcrest. So that's under the contract for present purposes. The second important limitation on what yes.
You said, I think, that under the contract was an important limitation on scope, because nothing outside the contract could be adjudicated, I think. What if someone defends by asserting a legal set-off? Are all categories of legal set-off limited to claims under the same contract? What about a set-off of mutual liquidated debts?
My lord, the courts have interpreted the statute so that issues arising under a different contract are not within the scope of a dispute under the construction contract. So that in the normal way, one cannot bring in a dispute under a separate contract.
Does that operate as a restriction on one's ability to defend by asserting a legal set-off?
My lord, it may well.
Has any authority addressed the tension between the scope for legal set-off and the notion that adjudication only deals with disputes within a particular contract?
My lord, I don't think it. I'm hesitating because certain cases might obliquely be said to come at the matter, but no, head on, it is generally accepted that adjudication is, as it were, internal to a single construction contract, except in those cases where under the scheme, if the parties consent, the adjudicator can hear disputes under different contracts, under 2 or more contracts. Those disputes have to be related, and a set-off of the sort your lordship describes could be a suitable relation. Typically, there is as we'll see in the authorities, adjudication is very much seen as a mechanism for sorting out disputes under one contract.
Yes, thank you.
Now, the words in section 108, a dispute singular, arising under the contract, it is very well established on the authorities that the dispute which can be referred is one dispute under one contract in one adjudication. That doesn't mean that a party can't start 2 adjudications at the same time, each to decide one dispute under the same contract, or each to decide one dispute under each of 2 contracts. But an important limitation is that if a party wants to use the same adjudicator in 2 concurrent adjudications, in a case where the scheme applies, certainly the consent of both parties is required. That recognises that the process is intense and abbreviated, and in a standard adjudication, it is not a good idea to have your adjudicator overburdened. That's as it were, the thinking. The limitation to one dispute under one contract is very well established, and Mr. Justice Coulson, as he then was, addressed the authorities compendiously in a case called Deluxe Art and Theme Limited and Beck Interiors, which is at page 745 in the authorities bundle. I might take you to that briefly. In that case, the claimant was a joinery subcontractor, which contended that it was entitled to an extension of time and to the release of retention monies. It referred each of those claims, each in a separate referral, to the same adjudicator, and it secured decisions in its favour on each claim. The court refused to enforce the second decision. My lords, in paragraph 1 on page 748, Mr. Justice Coulson identified the issue, whether under paragraph 8, subparagraph 1 of the scheme, an adjudicator has the jurisdiction without the consent of the parties to adjudicate at the same time on more than one dispute. Paragraph 15 is where the judge referred to what he described as the well-known principles as to the nature of a dispute for the purposes of working out whether what has been referred is one dispute or more than one disputes. The judge said, on an application of well-known principles, the dispute about extensions of time, loss and expense was a different dispute to the dispute about retention. Referenced the decision of Mr. Justice Aikenhead in Witney Town Council and Beam Construction. On an application of the principles set out in this case, the delay claim and the retention claim were both part of the same dispute because they related to what was due on the same date, the date of practical completion. That was the argument. Mr. Justice Coulson held that the proper application of the principles referred to in paragraph 38 in Witney Town leads to the opposite conclusion. As Justice Aikenhead said, this is the Witney Town case, a useful if not invariable rule of thumb is that if disputed claim number 1 cannot be decided without deciding all or parts of disputed claim number 2, that establishes a clear link and points to there only being one dispute. Paragraph 20 on the same page, having found that there were 2 disputes, the judge asked, does it matter? And he said, yes, it does matter. That's because the weight of the adjudication authorities is that an adjudicator only has jurisdiction to deal with a single dispute at one time. And he referred to the decision of the Court of Appeal on an application for permission to appeal in Bothmer and Mayhaven, which is in the bundle, but which I don't need, I think, to take you to. It's right to note that this conventional view was challenged by Mr. Justice Ramsey in his obiter remarks, starting at paragraph 75 of his judgment in Wilmot-Dixon Housing and Newlawn Housing Trust, which is also in the bundle. However, it's not clear to me that all of the relevant authorities were cited to Mr. Justice Ramsey in that case. I also note that in TSG Building Services plc and South Anglia Housing, Mr. Justice Aikenhead was not persuaded by this unconventional approach and said that the authorities were sufficiently well established now to suggest that only one dispute could be referred to adjudication at any one time. I agree with that. So, Lord, it is very well established, one at a time in adjudication. Well, the meaning of dispute and the extent to which the referring party can introduce issues not mentioned in the notice of adjudication was dealt with in the case of Cantillon and of Vasco, which you have at page 1593 in the adjudication bundle. The issue in the case was the anterior question of whether a dispute had crystallized before the reference to adjudication, purported reference, was made. And if it had crystallized, what was its scope? At page 1604, Mr. Justice Aikenhead dealt with what can be derived from the authorities on the meaning of, first of all, dispute, and also makes the point that what can be introduced by the referring party is limited to defences. If your lordships would kindly read paragraphs 54 and 55, I'd be grateful. My lords, you see there no less than 3 references to the to defences in the description of what a responding party can introduce. There are occasional references in the cases to a responding party's counterclaim. But when you look at the facts of those cases, what you see is the responding party making a cross-claim under the same contract in relation to the same project. So there is a close restriction on the ambit of what can be referred to adjudication. Nor is set off in any broad sense, well, in any sense actually, normally available at enforcement stage. So, for example, a contractual provision which might entitle a party not to comply with an adjudication decision will not be given effect. The obligation to comply with the adjudication decision is given primacy, and the authority for that is Fersen and Leverlux, which you have at page 1801. And if I might just take you very quickly to 2 remarks in the judgments in that case at page 1807. Lord Justice Mantell, I'm so sorry, that's the wrong reference. Paragraph 30 in the judgment of Lord Justice Mantell, 1809, forgive me. Talking about the intended purpose of section 108, and halfway through the paragraph, the contract must be construed so as to give effect to the intention of Parliament rather than to defeat it. If that cannot be achieved by way of construction, then the offending clause must be struck down. The clause in question in that case was a clause which provided that if the contractor were to determine the subcontract, all sums then due under it would cease to be due, and no further sums would be payable until completion of the works. It's a fairly commonly seen provision. In the case, the judge held, and the Court of Appeal upheld his decision on this ground, that the effect of the adjudication decision was that there was actually no entitlement to terminate the contract. So the clause which caused a difficulty in that case didn't apply. Nonetheless, it's clear from Lord Justice Mantell's judgment that if there had been a conflict between the contract and the adjudication decision, then it would be the contract that would fall away. And Lord Justice Longmore agreed at page 1810 that for the reasons given by Lord Justice Mantell, the obligation to pay the amount stated in an adjudicator's decision must take precedence over clauses 29, 8 and 9 of the contract to the extent there's a conflict. So it follows that if cross-claims and set-offs under the same contract do not prevail, then cross-claims and set-offs under different contracts and non-contractual cross-claims will not prevail either. This aspect of adjudication explains what Mr. Justice Coulson, Lord Justice Coulson said, paragraph 40 of the judgment, his judgment in the Court of Appeal, when he was talking about the way in which adjudication very often is not providing an assessment of the party's substantive rights. It is providing a provisional decision, often artificially constrained by the way that construction contracts provide for provisional payments. I mentioned earlier on the case of S&T UK and Grove Developments in the Court of Appeal last year, which dealt with what has come to be known in the industry as a smash and grab adjudication. That's a case where because an employer under a construction contract overlooks the need to serve a pay less notice, the contractor is entitled to payment of the sum it's applied for. It's entitled to an adjudication decision to that effect, and the court will enforce that adjudication decision, assuming no difficulty with jurisdiction or non-compliance with the rules of natural justice. Now, all of that is problematic from the employer's point of view, because his overarching obligation is to pay the value of the work. So an issue arose, well, could not the employer simply bring an adjudication of his own and ask for a valuation of the work done at the particular payment stage? The issue in S&T and Grove arose because the contractor, which had its adjudication decision and wanted it to be enforced, said, well, no, you can't bring your own adjudication. In effect, by reason of your agreement under the Act, and therefore in our contract, that you will comply with adjudication decisions, you're taken to agree now that the value of the work done is the same amount as I'm entitled to be paid. That went to the Court of Appeal, as I said, last year. If I could just ask you to look at page 2368, the decision, sorry, the report starts at page 2349. Sir Rupert Jackson gave the judgment of the court. At page 2368, he dealt with the question of whether the employer, having found that the employer could bring its own adjudication, whether the employer first had to pay on the adjudication decision in favour of the contractor. The argument you see fourth line down in paragraph 105 was that the employer could bring its own adjudication because the Act says he can do it at any time. So he could do it if he was swift before the contractor had been able to go to court and get summary judgment on his own adjudication decision. That was rejected, and in paragraph 107, Sir Rupert Jackson explained why. He said, both the Construction Act and the amended Act, that's to say the Construction Act as amended in 2009, create a hierarchy of obligations. As discussed earlier, the immediate statutory obligation is to pay the notified sum as set out in section 111. As required by section 108 of the amended Act, the contract also contains an adjudication regime for the resolution of all disputes, including any disputes about the true value of work done under clause 4.7. As a matter of statutory construction and under the terms of this contract, the adjudication provisions are subordinate to the payment provisions in section 111. Section 111, unlike the adjudication provisions of the Act, is of direct effect. It requires payment of a specific sum within a short period of time. The Act has created both a prompt payment regime and the adjudication regime. The Act cannot sensibly be construed as permitting the adjudication regime to trump the prompt payment regime. Therefore, both the Act and the contract must be construed as prohibiting the employer from embarking on an adjudication to obtain a revaluation of the work before he has complied with his immediate payment obligation. My Lords, I take 2 points from that. First of all, it illustrates the limits of what can be referred to a single adjudication. In litigation or arbitration brought to enforce the contractor's payment claim, there would be no difficulty in the employer pleading a defence, indeed, or a cross-claim based on what he said was the true valuation of the work. And both of those competing positions would be determined by the same tribunal in the same proceedings. In adjudication, the employer cannot raise his claim that his obligation to pay in respect of true value only be given primacy. And secondly, I take from that case that the right to adjudication at any time is not an unqualified right. It is subordinate in particular, as the court found, to the payment provisions which it was designed primarily, we say, to serve. My Lords, I wonder if that is a convenient moment for the 5-minute break, because I'm about to come on to another aspect of the regime.
Yes, thank you very much.
Thank you, my Lord. The third material feature of adjudication is the...
Can I just check, is Lord Kitchen with us?
Yes, Robert, I'm here. Thank you.
Thank you.
My Lord, the third material feature of adjudication is the inherent risk of error. It is a function, a product, perhaps, of two principal matters. The first is that adjudicators are not normally lawyers. It's often not desirable for them to be lawyers. They are asked to measure, assess, and value. So very often they are quantity surveyors. Other disputes may call for technical ability in other construction-related disciplines. That is not to say that there are not several adjudicators who are lawyers, but as has been observed, that's not the normality. The second feature, which gives rise to a reliability difficulty with adjudication, is the timescale. A standard adjudication under the Act and the scheme takes place within 4 weeks or 6 weeks. What that means in practice is that disclosure doesn't happen, cross-examination of witnesses doesn't happen, the normal processes in arbitration and litigation don't happen. Sometimes there's time for a site visit or maybe a brief hearing, but typically the entire process is conducted on paper. The adjudicator has to process within a very short time what can be a very significant quantity of written material. There is, of course, the referring party has the advantage of being able to ambush the other party, so very often it will have spent a good deal longer than 28 days preparing the materials it supplies with its referral. The other party might be taken by surprise, that's often the intention, and has to scrabble together. It, of course, doesn't have 28 days to respond. Typically, it will have 7 or perhaps a few more days to respond. So, my Lord, we've set out paragraph 24 of our written case, which is at page 196 in the core bundle. Quotations from the authorities where, again and again, this characteristic of adjudication has been recognised. I'm not proposing to take you to those cases, but perhaps I might give you page references to the bundle because we don't have those in the footnotes. The first, Wiegendahl Jensen, the judgment of Lord Justice Buxton, paragraph 15, is at page 626. And his lordship noted the exceptional nature of adjudication. Herschel and Breen property, the cross-reference in the footnote is actually wrong. The correct cross-reference, well, we don't have a copy of the judgment from which this is taken. It's unreported. And so in the footnote, we refer you to the decision in Rainford House and Cadogan, where it was quoted. And the page reference there is page 2295. Hart Investments and Fiddler, page reference is 2022. The whole point of adjudication is that speed is given precedence over accuracy. And then the decision of the Court of Appeal in Carillion Construction and Devonport Royal Dockyard, we take the quotation there from pages 710 to 711 in the authorities bundle. And as we say in that case, well, Justice Chadwick warned that the adjudicator is not an arbitrator or a judge. He's not expected to provide a definitive answer to any complex questions. He's there to provide an answer, not necessarily the right answer. And that is why, even when an adjudication decision is patently wrong, and the error is on its face, it will nonetheless be enforced unless there is a problem as to jurisdiction or as to compliance with the rules of natural justice. The need to have the right answer is subordinated to the need to have an answer quickly. An adjudicator is performing a limited task in a limited time, and very often by the nature of the dispute referred, as in S&T and Grove, what he's asked to determine is not a substantive assessment of the parties' rights and entitlements, but a technical one derived from the payment provisions of the Construction Act. In cases like that, one might say that the adjudication decision was doubly provisional. Well, that brings me on to the fourth, and we said most important characteristic of statutory construction adjudication, and that, which is that it produces a decision necessarily of temporary finality. It is that which makes adjudication exceptional and unique as a dispute resolution process in this jurisdiction. An adjudication decision of itself can never be final. One of three things is necessary for a final determination. The first, of course, is a judgment in litigation. The second, where the contract permits, is an award in arbitration. And the third is an agreement between the parties in compromise of their dispute. For that reason, with respect to the Court of Appeal in this case, and Bresco in this appeal, are wrong to describe an adjudication decision as one which may or may well become final, because, in particular, because neither of the parties challenges it. This is wrong because it's contrary to the Act, and it's contrary to the decision of this court on the last occasion that adjudication came before it. And so that was the case of Aspect Surveyors and Higgins Construction, which you have at page 589 in the authorities bundle. Well, unfortunately, this case wasn't cited to the Court of Appeal. The case vividly illustrates the danger of supposing that an adjudication decision is final simply because nobody has done anything about it, simply because they have let it lie. In that case, Higgins Construction secured an adjudication decision in its favour. It recovered about half of what it claimed in the adjudication. After the expiry of the limitation period applying to Higgins' claim, Aspect sought a final determination of the dispute by litigation. It sought a declaration of non-liability on Higgins' claim and repayment of the sum which Aspect had paid over in obedience to the adjudication decision. Higgins argued that Aspect's claim was statute barred, which led to the central inquiry in the case, which was what is the nature and source of Aspect's cause of action. Aspect's case was that there was an implied term, in effect, a necessary implication into the words of the Construction Act, section 108, and thence, by implication, into the parties' contract, an implied term triggered by payment in compliance with an adjudication decision, that the payer was entitled to repayment of sums shown on the final determination to have been overpaid once the parties' substantive rights were determined. And that case succeeded, not at first instance, but succeeded in the Court of Appeal, and the Supreme Court dismissed Higgins' appeal. And Lord, it's worth noting that in the Supreme Court, but not in the Court of Appeal, Aspect made an alternative case, which was that it had a right in unjust enrichment to recover overpayment in the light of the final determination. That was necessarily an alternative basis for the claim, not an additional one, because of course it's trite that unjust enrichment does not provide a remedy where the contract provides. decision of this court was that the implied term analysis, which the Court of Appeal had upheld, was right. Lord Justice Nance gave the court speech, and if I could take you to just one or two places in the speech, page 593, paragraph 4. Lord Nance noted the history and the fact that Higgins, having secured an adjudication decision in its favour and enforced it, I don't think it had to enforce it, actually. I think from recollection aspect simply complied with it as it ought. It did not commence any proceedings whether to recover that which it had failed to recover in the adjudication or otherwise. So no proceedings for a final determination. It allowed the limitation period applicable to its claim to expire. It was evidently content to let matters rest. It didn't ask Aspect to agree, and Aspect did not agree to treat the adjudicator's decision as final. Now, paragraph 14, in the last sentence, Lord Nance recognised that, well, that might be an understandable approach. Having got a favourable adjudication, it might be understandable that a party thinks it's done what it needed to do. Nonetheless, it is an erroneous and dangerous approach from the point of view of that party. In paragraph 14, Lord Nance said that by providing that the decision of an adjudicator is binding and that the party shall comply with it, paragraph 23, subparagraph 2 of the scheme makes the decision enforceable for the time being. It is enforced by action founded on the contractual obligation to comply with the decision, combined in a normal case with an application for summary judgment. The limitation period for enforcement will be 6 years from the adjudicator's decision. But the decision is only binding, and the obligation to comply with it only lasts until the dispute is finally determined in one of the ways identified. By use of the word until, paragraph 23.2 appears to contemplate there will necessarily be such a determination. The short time limits provided by paragraph 9, subparagraph 1, also indicate that adjudication was envisaged as a speedy provisional measure pending such a determination. There's nothing to prevent adjudication being requested long after a dispute has arisen and without the commencement of any proceedings. And then, after noting that there's no obligation on a party to seek a final determination, Lord Nance noted that either or both of the parties might understandably be content to let matters lie. In paragraph 15, he adverted to a point which Lord Sumption had raised in argument, which was the suggestion that an adjudication decision might be analogous to an interim payment in litigation. The court decided that that was not apt. The reasons explained there, which don't bear on this case in my submission. Paragraph 17 on the following page, after describing the issue in the appeal at paragraph 16 and paragraph 17, Lord Nance gave the rationale for the court's finding in a nutshell. Without the ability to recover such a payment, the scheme makes no sense. Adjudication is conceived as a provisional measure. At a cash flow level, Higgins remains entitled to the payment unless and until the outcome of legal proceedings, arbitration or negotiations leads to a contrary conclusion. But at the deeper level of the substantive dispute between the parties have rights and liabilities, which may differ from those identified by the adjudication decision, and on which the party making a payment under an adjudication decision must be entitled to rely in legal proceedings, arbitration or negotiations in order to make good a claim to repayment on some basis. So Lord, adjudication doesn't address substantive rights. It creates no estoppel. At page 600, Lord Mance returned to this theme, addressing Higgins' complaint that this was all rather unfair. It complained, paragraph 26, that aspect in being given a one-way throw, it could recover all or part of what it had paid out, but Higgins was barred by limitation by that time from pursuing the balance of its original claim. Lord Mance points out at 27, that consequence follows, however, from Higgins' own decision not to commence legal proceedings within 6 years from April 2004 or early 2005, the date of the breach on which Higgins' claim was founded, and so itself to take the risk of not confirming and to forgo the possibility of improving upon the adjudication award it had received. Adjudication was conceived, as I've stated, as a provisional mechanism, pending final determination of the dispute. Understandable though it is that Higgins should wish matters to lie as they are following the adjudication decision, Higgins could not ensure that matters would so lie, or therefore that there would be finality without either pursuing legal or arbitral proceedings to a conclusion or obtaining aspects agreement. So, however understandable the conduct, it was mistaken and to Higgins' own disadvantage to assume that simple absence of challenge creates a final determination. Well, just one further point before leaving that case, at paragraph 32 on page 601, in deciding the scope of what the court on a final determination in a case of that sort would be looking at, the court found that Higgins would be entitled to rely upon all aspects of its claim, the full claim, not merely the claim of which it had succeeded in the adjudication. That follows, about halfway down the paragraph, that follows from the fact that the adjudicator's actual reasoning has no legal or evidential weight. All that matters is that a payment was ordered and made, the justification for which can and must now be determined finally by the court. So all an adjudication decision is in litigation or arbitration for a final determination is an event in the history which may have given rise to material conduct by one or other of the parties, such as a payment in compliance with it. But it creates no estoppel. The proceedings are in no sense an appeal from the adjudication decision. There is no such thing as an appeal from adjudication decision. The underlying causes of action remain and are not discharged. As the Court of Appeal found all the way back in Cameron and Molam, the first case which I asked you to look at, it is the temporary finality of adjudication which most emphatically distinguishes it from arbitration. Cameron and Molam was a pre-Construction Act case, but the same has been held in two cases, one in Scotland, one in England, since the Construction Act. If I might give you the reference to the Scottish case and take you to the English case, the Scottish case is Gillies, Ramsey, Diamond and PJW Enterprises, which is at page 800 in the bundle. The judgment was given by the Lord Justice Clerk, who is Lord Gill, and the references are paragraphs 20 and 21 at page 807. The court made clear there that adjudication is not a form of arbitration. Lord Justice Clerk said, adjudication is sui generis, it is one of a kind. The English case is Herschel and Breen property. The decision in that dispute, which we do have in the bundle, it's at page 813. Decision of Mr. Justice Dyson, as he then was. the issue in the case was whether a party who had, oh, my lord. I'm so sorry, I can't hear you.
Hear me now?
I can now.
Before we go to that, can I just raise with you a point my eye is lit on in the judgment in the Aspect case. If you go to paragraph 28, which is on page 600 in the electronic bundle.
Yes.
Lord Mann says, look, further, as Mr. Justice Aikenhead pointed out in his judgment, this is not one of those, quotes, very typical building contract cases where there are set-offs and cross-claims on each side, each allegedly overtopping the other. In such cases, if there is an adjudication award within 6 years from performance without any further proceedings, both sides are, after the 6-year period, time barred in respect of any claim to any balance. I'm just wondering about the reference there to cross claims. You had told us earlier that it wasn't possible to have a dispute referred to adjudication which encompassed a cross claim.
A cross claim which does not operate as a defensive set-off. Yes.
Yes, I see. So are we to? I suppose we'd have to look at what Mr. Justice Aikenhead said, but you would take that as referring to cross claims. Well, when it says set-offs and cross claims, you would read what is referring to there as cross claims which operate also as a form of set-off.
My lord, yes, but actually, my submission, Lord Justice Mance wasn't addressing any question as to the scope of what might be referred to a single adjudication there. The submission, it was Higgins' submission that if a party which paid up in response to an adjudication decision had a right which was triggered by that payment, came into being because of that payment, so that it had 6 years from then to seek a declaration of non-liability and repayment, that would cause chaos in typical building contract cases where there are very often claims, cross claims. That was the context. It was the limitation question rather than anything, in fact, to do with what could be referred within a single adjudication. My lord, if it would be helpful, we can supply the decision at first instance so that you can see what that paragraph related back to. We don't have it in the bundle, but of course we'll be happy to do that. It would be helpful. My lord, if I may go back to Herschel and Breen at page 813. My lord, the issue in that case was whether a party who had started proceedings could start an adjudication on the same dispute, and it was held that there's nothing objectionable in that as a matter of law, at any rate. But in the course of his decision to that effect, Mr. Justice Dyson rejected the proposition that there was even a close analogy between arbitration and adjudication. And I would invite you to read paragraphs 16 and 17 of his decision at page 817. Lords, we say, in the light of those key features of adjudication, it cannot be treated as if it were adjudication light. It is a fundamentally different process. That is important in the context of this appeal, of course, because, cross appeal, because the Court of Appeal proceeded from what it took to be a concession that Bresco's claim could have been referred to arbitration, almost directly to the court's conclusion that the claim could be addressed in adjudication. And the same error is repeated by Bresco in this appeal. I'll return to that when I address the cross appeal proper. What I propose to do first is briefly to look at insolvency set-off and the material features of that. My Lords, I take as read, yes, I'm so sorry.
You briefly mentioned this morning, I think Mr. Justice Aikenhead's rule of thumb about whether there was a single or more than one dispute. I think it's to be found at the end of a whole series of tests in TSG Building Services and South Anglia Housing. Do you accept that rule of thumb?
Well, my Lord, as a rule of thumb, of course, but there is a case, the name of which I'm afraid for the moment escapes me, it's in the bundle, where Mr. Justice Aikenhead himself found that it didn't work, but nonetheless there was still a dispute. So it's not invariably reliable. If it's helpful, the original source, as you point out, that the rule of thumb is an extract from a list of principles.
Yes.
Of what is a dispute. And the original source is Mr. Justice Aikenhead's decision in Witney Town Council and Beam, which is at page 1461. And it's his paragraph 38 at page 1483 to 1485. It is, in short, a broad, sensible, pragmatic approach is taken, and the court has not been inclined to accept what it regards as over-technical, over-legalistic analyses of what a dispute comprises. You perhaps won't be surprised to hear. My Lord's, insolvency set-off. I will take as read, if, my Lord.
I just wanted to ask whether you accept that in relation to the scope of what is a dispute, the test is the same in adjudication and in arbitration.
My Lord, it is, and the court has said so. The Witney Town Council and Beam adopts a similar approach. So, as I say, not an over analytical, over legalistic approach. It looks at what the parties were arguing about. So obviously, the dispute must have crystallized. So it takes into account everything and sees what of those matters have been brought into the referral notice and what then the defendant can set up as a defence, as was said 3 times in Cantillon and Vasco. So by way of defending itself against the claims brought forward into adjudication. But all the responding party can do is, as it were, to fill out the dispute. The dispute must exist and it must be referred.
Thank you.
Well, I was going to say, I hope I might take as read the general operation of the insolvency legislation in this country, the very close similarities between the regime which operates on in a distributing administration and in a liquidation, and focus directly upon the provision of most interest in this appeal, which is Rule 14.25 of the Insolvency Rules 2016. That is at page 581, the authorities bundle. It was, in substance, it doesn't differ from its predecessor under the 1986 rules, which was Rule 4.90. It applies where, before the liquidation, there have been mutual dealings between the company and a creditor of the company, proves or claims to prove for a debt in the liquidation. This is established as a matter of authority that a proof does not have to be submitted. The creditor must, though, have a provable debt. Sub-rule 2, an account must be taken of what is due from the company and the creditor to each other in respect of their mutual dealings, and the sums due from the one must be set off against the sums due from the other. If there is a balance owed to the creditor, then only that balance is provable in the winding up. If there is a balance owed to the company, then that must be paid to the liquidator as part of the assets. And the rules make clear, as I think they have always done, that what is encompassed within that set-off is not limited, of course, to causes of action which might have crystallized by the liquidation date. The definition of a debt for these purposes is far, far wider. First of all, sub-rule 7 at the foot of the same page, a sum must be treated as being due to or from the company for the purposes of paragraph 2, whether A, it's payable at present or in the future, B, the obligation by virtue of which it's payable is certain or contingent, or C, its amount is fixed or liquidated, or is capable of being ascertained by fixed rules or as a matter of opinion. And that broad encompassing approach is a characteristic of liquidation, which is unique to it. And there are three key features of insolvency set-off, which I invite you to bear in mind. First of all, the nature and effect of insolvency set-off are that it is self-executing. It takes effect automatically on the insolvency date. It has a substantive effect on the parties' rights against each other. That substantive effect is that claims and cross-claims, whether already crystallized or whether merely prospective, are extinguished pro tanto. All that remains of the pre-existing choses in action is a claim to the net balance. And what therefore falls to be determined is the direction and the quantum of the net balance. Assuming there is one and there isn't, they don't cancel each other out. The second key feature is that the statutory account which the rule requires to be taken in the light of insolvency set-off is comprehensive and it is a singular event. We cannot have two accounts which come to different answers. And thirdly, insolvency set-off cannot be cannot be excluded by contract. The classic exposition of the mandatory retroactive nature of insolvency set-off, the operation of the hindsight principle, found in the decision of Lord Justice Hoffman sitting as a judge at first instance in M&S Fashions and BCCI, which you have at page 1069. And page 432 at letter F through to page 433 at letter F is the exposition. My lords, that's at page 1076, and I would invite you to remind yourselves of that passage if you would. My lords, Lord Hoffman developed Lord Hoffman developed that analysis, of course, in Stein and Blake, which is quoted extensively in the judgment of the Court of Appeal in this case. But I wonder whether I might take you to the decision. It's at page 1281. I'm so sorry, that's the decision of the Court of Appeal is at 1281, but I would ask you to pause there before seeing the position, to see the position the Court of Appeal had arrived at. In the headnote on page 1282, the decision was, in the Court of Appeal, was that section 323 of the Bankruptcy Act, that's the equivalent of the current rule 14.25 in liquidation, did not change the nature of set-off, but widened the categories so that providing the claims were mutual and measurable in money terms, set-off applied, that the claims remained in existence until such time as the set-off was complete and a balance of account taken. Well, that is Bresco's position in the current appeal, as we understand it, that insolvency set-off does not alter the substantive nature of the parties' causes of action. They remain and can be the subject of a reference to adjudication. Well, we say that that is an untenable position in the light of the decision of the House of Lords in Stein and Blake. That was a case in which proceedings were on foot before the bankruptcy of the claimant supervened. His trustee assigned his claim, his cause of action, back to him, and he sought to carry on. And the decision of the court was that the trustee could not assign the claim because the effect of insolvency set-off was to extinguish it. What the trustee could assign was the net balance, and he had done so. I'm sorry, Ma'am.
Sorry, it's Lord Briggs. I was, I'm afraid, disconnected from 12:29 until now, but I'm quite happy to follow up what you've been saying over the last 3 minutes, if you're happy, by looking at the recording in due course.
My Lord, I'm very grateful. I suspect it will be very familiar to you. I mentioned M&S Fashions and BCCI, Lord Justice Hoffman's exposition of the mandatory retroactivity and hindsight principles on insolvency set-off. So,
thank you.
Just coming on to Stein and Blake, and my lords, the relevant passages are relatively lengthy, so perhaps I could just give you the page references to them. In section 4 of the judgment, which starts on page 1305, Lord Hoffman compared insolvency set-off, because the same principles apply whether it's bankruptcy or liquidation, insolvent liquidation anyway, compared with statutory legal set-off. And he identifies, I think, in the course of this judgment, 3 differences, but 2 here. First of all, legal set-off doesn't affect the party's substantive rights until judgment, when the causes of action merge in the judgment. But just above little e, bankruptcy set-off, on the other hand, affects the substantive rights of the parties by enabling the bankrupt's creditor to use his indebtedness to the bankrupt as a form of security. Instead of having to prove with other creditors for the whole of his debt in the bankruptcy, he can set off pound for pound what he owes the bankrupt and prove for or pay only the balance. Whilst that effect of insolvency set-off is a key advantage, an exceptional advantage, which is given to a creditor with a cross-claim. It is not available to other creditors. And the second difference, which Lord Hoffman identified just below letter F, is the difference in ambit between insolvency set-off and a legal set-off. And I've mentioned when looking at the provision of Rule 14.25 that it is far wider than simply causes of action which are crystallised by the insolvency date. Section 3 of the judgment on page 1307 talks about the occasion for taking the account. At letter C, Lord Hoffman said, the taking of the account really means no more than the calculation of the balance due in accordance with the principles of insolvency law. And he dealt with the point that it is not necessary for a proof to have been submitted. At letter E, he said, thus the account to which Section 3232 refers may also be taken in an action by the trustee against a creditor who, because his cross-claim does not exceed that of the trustee, has not lodged a proof. And the consequence of that, just above letter F, Lord Hoffman explained, was that the operation of insolvency set-off is not linked to any procedural step in the bankruptcy, in contrast to legal set-off. And just below letter F on the same page, the account in accordance with the statute must be taken whenever it's necessary for any purpose to ascertain the effect which the statute had. My lord, at page 1309, Lord Hoffman came on to address the central question in the appeal: do the causes of action survive, so as, for example, to be capable of assignment separately? And his answer was categorical. The principles so far discussed should provide an answer to the first of the issues in this appeal, namely whether, if A, against whom B has a cross-claim, becomes bankrupt, A's claim against B continues to exist as a shows in action, so that A's trustee can assign it to a third party. In my judgment, the conclusion must be that the original shows in action ceases to exist and is replaced by a claim to a net balance. If the set-off is mandatory and self-executing and results as of the bankruptcy date in only a net balance being owing, I find it impossible to understand how the cross-claims can, as shows is in action, each continue to exist. And then by reference to the decision of Mr. Justice Neal in the Farley case, just above letter G, sorry, just below letter E, Lord Hoffman said, cross-claims must obviously be considered separately for the purposes of ascertaining the balance. For that purpose, they're treated as if they continued to exist. So, for example, the liquidator or trustee will commence an action in which he pleads a claim for money due under a contract, and the defendant will counterclaim for damages under the same or a different contract. This may suggest that the respective claims actually do continue to exist until the court has decided the amounts to which each party is entitled, and ascertain the balance due one way or another in accordance with the section. The litigation is merely part of the process of retrospective calculation, from which it will appear that from the date of bankruptcy, the only shows in action which continued to exist as an assignable item of property is a claim to the net balance. And just very briefly over the page, at page 1310, just below letter B, the account envisaged by section 323 would have to be taken twice were that not the case, because it would mean that the liquidator or the trustee in bankruptcy by assignment would cause the account to be taken on two different occasions, taking into account a different cross-claim in each case, and that is not acceptable. The account envisaged by section 323 would have to be taken twice with possibly different results when the section plainly contemplates a single calculation. That is why we say the account is a singular event. Now, my lord, in Bresco's written case, it appears that they rely upon three cases which they say undermine the analysis we suggest is clear on the face of Lord Hoffman's judgment. The first is White and Eckert, which is at page 1372. It's a decision of the Privy Council in which Lord Hoffman gave the speech of the board. Well, the Privy Council in that case concluded that a liquidator was entitled to reject a creditor's proof where under the proper law of the debt it had been discharged before any distribution was made. The issue was whether a winding up order of itself had any substantive effect on the debt. The argument for the creditor was that it did, that the effect of the winding up order was to generate a new right in substitution for the creditor's existing debt, a new right to share in the liquidation, and that right was governed by the law of the place where the liquidation was taking place. On the facts of the case, that would have meant a recovery by the creditor. So it wasn't a case about insolvency set-off at all. Paragraph 26 to 27 on page 1394. Sorry, paragraph 27, I think we can confine it to. Lord Hoffman said the winding up leaves the debts of the creditors untouched. It only affects the way in which they can be enforced. And he observed that the liquidation is a collective enforcement procedure that results in pari passu distribution of the company's assets. The winding up does not either create new substantive rights in the creditors or destroy the old ones. Their debts, if they're owing, remain debts throughout. They're discharged by the winding up only to the extent they're paid out of dividends. And Lord Bresco relies upon that case, as we understand their written case, to say that Lord Hoffman there departed from what he had said in Stein and Blake. But we say he did nothing of the sort. He wasn't addressing the effect of insolvency set-off. And the substantive effect of insolvency set-off on debts is recognised to be an exceptional effect. It is generated by Rule 490 as was Rule 14.25 now, only in the situation where, as between company and creditor, there are both claims and cross-claims. My lord, that was made clear in the decision of this court in Lehman International, which is at page 900 in the bundle. Now, there are several issues in that case. One of them was to do with the payment of foreign debts in foreign currencies. Under the insolvency rules, debts denominated in foreign currencies have to be converted to sterling at the rate prevailing at the insolvency date. In that case, it was an administration. But they may not be paid at that date. In fact, normally, there is a little time between the insolvency date and the date when any payment is made to creditors. And usually in that case, there was a surplus in the administration, and there had been a depreciation in the exchange rate between the date of the administration and the date on which the administrators were proposing to make payment. So the creditors argued that they had a surviving right to be paid from the surplus the shortfall between the value of their debt at the payment date and the value of their debt converted into sterling at the rate prevailing at the administration debt. It was a matter of the construction of the insolvency rules relating to the treatment of debts in foreign currencies. However, in the course of analysis, bear with me a moment. Page 945, Lord Neuberger referred to the passages in White and Eckert, to which I've just referred. He said the dicta in White and Eckert must, as Lord Justice Lewison said, that was in the Court of Appeal, on any view be no more than a broad generalisation, as they are self-evidently subject to important exceptions, including statutory set-off, disclaimer of onerous property, and the treatment of future and contingent debts. So statutory set-off, exceptional. It has the exceptional effect described by Lord Hoffman in Stein. And Lord Sumption, although he disagreed in the analysis with Lord Neuberger and the majority, agreed in the result on the construction of the rules, and he agreed on that particular point, the exceptional character of insolvency set-off, at paragraph 198 on page 972. He repeats the point which Lord Hoffman had made in White. English corporate insolvency law has from its inception adopted the principle which had always been fundamental to bankruptcy, that liquidation was a mode of collective enforcement of debts which operated procedurally and administratively rather than substantively, and did not itself extinguish the creditor's liabilities. And then in paragraph 199, on page 973, he identified insolvency set-off as an exception to that. Just above the letter C, the purpose and character of the process of proof of debt and distribution did not change. That's with the 86 insolvency rules. Then he said, there are, as there always have been, specific circumstances in which the current scheme of corporate insolvency does provide for a discharge, that is to say, of existing rights. The most significant of them is mutual set-off, which occurs automatically under rules 2.85, that's administration, and 490, that's liquidation, in circumstances when set-off would not necessarily be available at common law. Set-off by its very nature brings about a pro tanto discharge of the liability. The effect of pro tanto discharge, of course, is that if there is a net balance, then that is all that survives of whichever of the claim or the cross-claim overtops the other. My lord, the third case on which Bresco relies, which I should deal with because Mr. Justice Coulson also adverted to it, is the decision of the Court of Appeal in Re Kaupfing, Singer and Friedlander, which is at page 886. At paragraph 19 of his judgment in this case, Lord Justice Coulson quoted from the judgment of, sorry, I'm looking at the wrong case, the judgment of Lord Justice Etherton in the Kaupfing case. But my submission will be he took that passage out of its proper context. My lords, forgive me, I have an incorrect, yes, no, I have it now. This case concerned the operation of the rules governing the discounting of prospective debts. So debts in which no payment was due as at the insolvency date, but under the terms of the relevant arrangements would become due in the future. Under the rules, now I think the equivalent rule now is rule 14.44, which you have at page 577, but perhaps don't need to turn up. The rules make provision for the discounting of future debts to their present value. I think that at a rate of 5%, in order that they can be dealt with as at the liquidation date, as classic principles require. The question in the case was to how much of the prospective debt did the discounting rule apply? And the answer which the court gave was as much as is necessary to achieve set-off, in a nutshell. And you see that from in the head note on page 887. At paragraphs H6 and H8. In particular, H8, there's no coherent or rational policy reason to release a creditor from a substantial part of his indebtedness to the company when and to the extent that such release was not necessary to achieve a set-off of cross-claims. That was a case addressing the operation of the discounting rules. It was not a case which addressed the principle articulated in Stein and Blake. Lord Justice Etherton said as much at paragraph 36 on page 897. He said, I don't accept that the principle in Stein and Blake that on taking of the account for the purpose of insolvency set off, the original causes of action are extinguished, has any relevance to the present issue. He then summarised Stein and Blake, and in the final sentence concluded, that has nothing to do with and cannot assist in resolving the question whether, as a matter of the proper interpretation of insolvency rules 2.85 and 878, the discounting mechanism in rule 2.105 applies further than is necessary for the purpose of establishing the amount of a distribution to be made to the creditor. So, my Lord, when in his judgment, Lord Justice Coulson quoted from paragraph 33 on page 896, he was ignoring the court's declaration that none of this impinged upon or indeed had anything to do with Stein and Blake. And I've suggested that the reason why Stein and Blake wasn't engaged there was that the issue was simply the proper construction and operation of the statutory rules about discounting. An alternative possibility might be this, that Lord Stein was addressing causes in action which were causes of action which had crystallised by the insolvency date, because his concern on the facts of Stein and Blake was with legal proceedings. A merely prospective debt is not a cause of action which can be sued upon in legal proceedings, as at the insolvency date, because the date for payment has not yet arrived. The statutory definition of insolvency dates, of course, is far wider than crystallised causes of action. So that may be an alternative explanation, if it's needed, for why. Yes, my lord.
Can I just what the relevance is of Stein and Blake and this whole kind of discussion, because we're not concerned here, are we, with whether shows in action is assignable or not at the insolvency date. First of all, it's accepted in Stein and Blake that litigation and arbitration can be pursued to determine to help in assisting the statement of account, and adjudication is no different. But if anything, surely adjudication is a fortiori, because the point you were making to us earlier is that the right to an adjudication isn't a substantive right or shows in action or anything of that kind. It's just a provisional assessment. So the ability to assign shows in action doesn't bear on this at all, does it?
My lord, we say it does for this reason, that the effect of Stein and Blake is that a cause of action which exists as at the liquidation date ceases to exist where insolvency set-off operates. It is replaced with a claim to the net balance as between company and creditor. Now, that net balance, it could be said, is capable of being referred to adjudication. That isn't what happened here. That's the first point, which is about the characterization of what was referred. Well, the second point is that adjudication is not an appropriate forum in which to determine the net balance. In particular, because the statutory account must be a one-off event. There's no provision under the insolvency rules for it to be provisional in the sense that adjudication is provisional. It must be taken, and when taken, it is final, subject to the jurisdiction which the rules provide for the court to look again at the matter. That is a statutory jurisdiction under the various provisions of the rules. There is, we say, no room for a halfway house of the sort that adjudication would provide, and no good reason for it either. It's not what adjudication was introduced to do or designed to do. It is simply an additional layer of trouble and expense, and the expense is the creditor's expense, my lord. I'm sorry, I can't hear you, my lord.
Hello, can you hear now?
I can now.
I suppose my question arising out of your last submission could be summarised as why not? Take a case where there's a long history of mutual dealings between a now insolvent company and another person, another company, let's say, with a number of different claims and cross-claims, some of which are disputed and some of which are not disputed, some of which may even be the subject of pending proceedings at the time of the onset of the liquidation. There would be nothing, or no reason to prevent, would there, some of those disputes being resolved by, let's say, mediation, some of them being resolved by early neutral evaluation. And if you would acknowledge that they can be picked off one by one, as it were, to narrow the overall account that ultimately has to be taken, or the matters that might arise on it, why cannot some of those disputes be resolved by adjudication, albeit obviously in a provisional way, in much the same way as preliminary neutral evaluation is not final or binding if anybody wants to go on arguing about it?
My lord, 2 points in response to that. First of all, we don't accept that it is permissible to pick off parts of the account and determine them separately. In litigation, in arbitration, in most arbitrations, there is a much broader ability to bring before the same tribunal all the relevant claims and cross-claims, so that the tribunal, court or the arbitral tribunal, is determining the net balance, so the account is taken. That isn't available in adjudication, as I've said, because of the limitations on what can be referred to adjudication and what can be raised in response to a referral. And the second point is that mediation does not of itself resolve a dispute, obviously, nor does early neutral evaluation. Neither of those processes produces a final determination. The final determination, if it happens, is the parties' compromise agreement in the light of what goes on at the mediation or in the light of the early neutral evaluation. And the second distinguishing characteristic of those processes is that they are wholly voluntary. Unlike adjudication, which is imposed upon the parties by statute, and which in practical terms it is difficult for a responding party to ignore, because he is, if the decision against him is enforced, he's going to have to pay it, and he's not going to get his money back. He's going to be deprived of the benefit of insolvency set-off, the pound-for-pound security. It's very difficult for a party who is responding to a reference to adjudication to say, I'm not going to have any part of it. So there is, in practical terms, a compulsory aspect to adjudication once it's started.
Ms. Sinclair, we may need to return to this question after the adjournment, but I wonder if this might be a convenient point at which to adjourn.
My lord, yes, of course.
Very well then. Then we'll rejoin this hearing at 2 o'clock.